Hello and welcome. You're watching Big Picture with me, Vishal Dahiya, and today we're going to talk about the Taxation Laws Amendment Bill 2021, which has been cleared by the Lok Sabha this week. And this is a really significant bill because this deals with the issue of retrospective tax. We'll try and understand what exactly is, the concept of retrospective tax, and also how this particular bill and its passage will impact the business and investor sentiment as well here. And for more on this, we're joined by two distinguished experts. Let me first introduce them to you, beginning with Mr. Dilip Chenoy, Secretary General of FICCI, is with us. We're also joined by Mr. Bhattacharya, Editorial Director of Business Standard. Welcome, both of you gentlemen. Let me begin with you, Mr. Bhattacharya, and let's first start by understanding as to what exactly is the issue of retrospective tax. If you could take us, a little bit into the history of the issue and make us understand why are we so concerned about this issue?
Well, in brief, Mr. Dahiya, if you want to understand the implications of the retrospective tax amendment law that has been presented in Parliament, and actually Lok Sabha has already passed it, is to understand two elements in it. One is the retrospective element in it, and the other is the capital gains tax element in it. So what has happened is that in 2006 and 7, there was this company, Vodafone, which is a British company. It acquired the ownership rights of an Indian company called Hutchison SR by buying its controlling stakes that was in Cayman Islands. Now, when Vodafone bought those shares in Cayman Islands, it actually became the owner of Hutchison SR. Now, the shareholding of Hutchison SR, in other words, moved from Hutchison Whampoa to Vodafone. Now, there was a capital gains that arose because the price at which Hutchison Whampoa had bought it from the SR group and the price at which they sold to Vodafone, there was substantial appreciation of their money. So there was some sort of a capital gains, and in the normal course, capital gains tax would have been due on this transaction to the exchequer.
Okay.
But because this transaction happened completely offshore, in other words, not within the Indian tax jurisdiction, the companies did not make any provision for capital gains tax allocation for the Union Government of India. Now, when the Government of India realized that such a big transaction took place, which pertains to an underlying assets which actually located in India, the income tax authorities filed a tax notice against Vodafone and Hutchison Whampoa, saying that you have evaded or avoided paying capital gains tax on this.
Okay.
Now, this went on to become a legal case, and they went to the High Court. The High Court ruled in favor of Vodafone, saying that no, they don't need to pay any capital gains tax. But in 2012 or 11 end or 2012 early, the Supreme Court ruled that the government of India is on the wrong in terms of levying that capital gains tax because the transaction took place outside the country, and the current laws did not allow the government of India to levy a capital gains tax on an international transactions, even when the underlying assets of that transaction are located in India.
Okay.
When that happened, Pranab Mukherjee was the finance minister at that time, the UPA government. They decided to introduce a piece of legislation which became the Vodafone tax, or a retrospective amendment to the capital gains tax, which essentially said that from 1962 April onwards, any capital gains that arise out of a transaction, even if it is international in nature, but if its underlying assets are located in India, then the entities will have to provide for capital gains tax to the union government. Now that is what is now being corrected, because that created a lot of controversies. At least 17 companies were served with notices, Vodafone, Cairn, and many other companies under different provisions, and the government started extracting the capital gains tax because the law had been changed. The Supreme Court had said there is no law, but when the government said, I have changed the law, so law is retrospective amendment on capital gains tax. So from 62 onwards, any transaction tax takes place would mean that the government can levy that tax. Now, what this amendment does in brief, Mr. Dahiya, is that it says that transactions that took place before 2012 will not be coming under the provisions of the capital gains tax law, which was introduced in 2012.
Okay. So the cutoff period.
All transactions from 2012, please remember, will continue to pay the capital gains tax on any international transactions, provided the underlying assets are located in India. So that, in brief, is what the government has done. It ended a long controversy, which had created a lot of misgivings, a lot of bad vibes in industry about the government's tax administrators. So that is a good way forward.
We'll come to the finer points of the amendment itself there as well. Back to you, Mr. Bhattacharya. But let me first bring in Mr. Chenoy here. Mr. Chenoy, obviously I'd like to seek your opinion on how the new amendment, as far as the retrospective tax is concerned, impact the investment opinion or the investor sentiment out here. But before that, if you could tell us what was industry's opinion as well as a view, and how did the industry deal with the issue of retrospective tax over all these years since that amendment was brought in 2012?
I think, Mr. Dahiya, there are two issues, like Mr. Bhattacharya said. One was the taxation of assets in India which are done overseas, and the second was the retrospective nature of the amendment. So I think the first thing, the general belief in industry was that if you're carrying out a genuine transaction where both the entities are abroad, then the law at that time did not provide for any taxation in India, and the capital gains tax, which Mr. Bhattacharya actually explained so well. So, as I said, if the law was non-existent, then why have this? And there was a kind of uneasiness about that.
Mm-hmm.
The second is that when this government came into power first in 2014, they had actually said that they will address this whole taxation issue at a given point of time. And then the feeling in industry was that anything retrospective, taxation prospective from the current date when it is actually announced going forward, the government has the sovereign right to tax. So therefore, it is easy. But retrospective tax, and this being the precedent in other areas, what was really worrying industry, and they never had, they always lived both in the constant listing of some deal that they've done today and or done yesterday or day before would be taxed retrospectively in this manner. So I think the removal of this retrospective taxation and saying that it is only applicable from the 2012 onwards is a very positive step. Mr. Bhattacharya said there were 17 companies, and the two most famous ones, of course, Vodafone and Cairn here. And, not only that, but other companies who possibly were not in the, in the limelight, or did not come into the, into this, who are always living under the kind of this sword hanging over them, that the taxman could come and retrospectively actually tax any transaction that they've done. I think all those elements have actually gone away. I think this government had come with the promise in those days to actually address this. So the reputation and the state of of India has actually dramatically improved post this. And industry is very positive. Industry first welcomed the introduction of the bill. And as you know, the bill was introduced through a supplementary agenda and suddenly came up for discussion, and the finance minister announced it, and then next day it was actually passed. So it's a very positive step. I think it has really, it is one of the things that has lifted the confidence and the sentiment in industry, not only in India, but all over the world.
Okay. So industry seemingly is pretty much relieved out there, as Mr. Chenoy is pointing out with this amendment. Mr. Bhattacharya, you earlier talking about the crux of the amendment. So in terms of what exactly does it say, apart from the fact that before 2012 there will be no retrospective tax which will be put in place. In addition to that, what kind of impact will it have on the investor sentiment? Because as Mr. Chenoy is pointing out, this was sort of a sword hanging over the industry's head.
Well, there are two kinds of impacts which we can look at. The first impact would be on all prospective investments or investments that are already there, and transactions may take place. Now, there's a complete clarity that no retrospectivity clause will be brought in, or even companies, 4 years ago or 5 years ago, something they may have been a capital transfer or capital gains arising out of some transaction. So the government has actually fulfilled its promise. It may be said that it is a late fulfillment of the promise. The promise was made in 2014 by the then Finance Minister, Mr. Arun Jaitley, that there will be no retrospectivity in all tax legislation, and two, that the current cases will be allowed to reach their logical conclusion. Now, in both the Vodafone and KN cases, they had reached their logical conclusion maybe a year ago. Now, you might argue that why wasn't such a law brought in a year ago? But that's a matter of debate. But the fact that this has ended this suspense over what will be the government's approach to KN as well as the Vodafone's tax cases, which both the companies have won an international arbitration. So therefore, the second impact would be that what kind of conditions the new law imposes on resolution of those 17 cases. Now, the first condition is that the companies that have been served with the notices in the past will have to withdraw all their legal cases, if any, they have filed against the government of India. That is number one. Number two is that both Vodafone as well as KN must withdraw those cases, and they should not expect to claim any damages from the government of India, nor expect any interest payment from government of India. This is particularly relevant for KN.
Okay.
Because out of KN's 8,000 crore of dues, there is another about 40 crore of interest that has also accumulated. Now, if the companies agree to these two conditions, I think the law will have a major impact, and one has to see how these various companies, 17 companies in particular, actually deal with the government after the passage, when the bill receives the presidential assent. How do they deal with those cases? But my sense is that no company, if it wants to do business in a country as large as India, with a market as large as India's, will like to get into a dispute with the sovereign. And if there is a legal certainty which says that there will be no retrospective application of capital gains tax on any transaction that happened before 2012, I think this is going to put an end to a lot of uncertainty, and companies will be able to move in an area without the fears of what the UPA government had been accused of having unleashed tax terrorism. So I think there is a tax terrorism fear is there. There is a fear of tax uncertainty. And if the law is passed and if it receives the presidential assent, which it will, my sense is there will be greater certainty and the industry will be more forthcoming as far as committing more investments in this country.
Okay, indeed, certainty, stability, and as far as tax laws are concerned, clarity out there is something which the industry has always been asking for and looking forward to as well. Mr. Chenoy, your views there on this very important aspect of the bill, or rather the amendment which is being brought to this particular bill, vis-a-vis the legal tussle which has been ongoing with some of the companies, as Mr. Bhattacharya was pointing out. Looks like that's the best way out for all those companies who've been involved in the legal tussle.
Yes, I think, like Mr. Bhattacharya explained that, the bill itself has the conditions in which companies who have been under this retrospective tax and, the 17 plus companies, what is the process going forward and how they can settle the past. And this is not a kind of a government order. It's actually part of the bill. So it's a legislative intent, and the parliament actually passes it and the president approves it, which we expect will happen. Then I think it will be in the interest of everybody if all those companies actually agree to follow what is in the enshrined in the bill, and then resolve this issue. That would be the best interest of everybody. Yes, you could say that there's a question of interest or something is there, but I think from what is actually coming out informally in some of the news reports, there have been discussions between both the large companies who were involved, Vodafone and Ken, and there has been discussion on the best way to resolve it. And I think if this is resolved, then it will actually also improve the credibility of industry. And these two organizations that they have actually looked at partnering with the government of India and the sovereign in resolving an issue in the most amicable way. And the best thing is to just bury the past and go ahead.
Okay. One more thing, Mr. Chenoy, now that we're talking about the taxation issues and specifically the retrospective tax issue, and you also mentioned in your first response how it is really important for the industry, for the business community and the investors as well to have complete clarity on how the taxation laws work, how they should move ahead. In those terms, when we're talking about the expectations of the industry and the investors here as well, vis-a-vis India, how do you think moving, things will be moving ahead from here onwards? And also, let's not forget that the Prime Minister himself had an interaction with the leaders of the business community after this bill was cleared by the Lok Sabha.
Yeah, so, I think yesterday was this actually this interaction when it actually happened, and also it is the interaction with exporters. So first, I think the first thing is that it raises the credibility of government. If there's a genuine issue of industry which is presented in a logical way, and which is the legal process is not sub judice literally, then the government is willing to actually listen and find a solution. So government is willing to listen and find a solution to genuine problems of industry was the first big message that comes out of this. Second, as Mr. Bhattacharya said, that they actually promised this in the 2014, when the then finance minister, late Mr. Arun Jaitley, actually said it. They would have reasons because they had to wait till these things came under came to the logical conclusion, so that it again enhances the credibility of it going forward. The third thing, and which is very important, is that this whole retrospectivity actually goes away, and perhaps it will not be introduced in any other form in any other taxation going forward, and because this will be a very good precedent which should be there. Of course, if you look at the right of the sovereign to tax, that's a separate issue. but going forward, it is there. And I think events have actually unfolded over the last 2 or 3 years. Last year in the budget itself, you had announced the lowering of tax for manufacturing sector to 15%. You had this whole taxation of 25%. The two alternative ways of calculating individual income tax, with exemptions a certain rate, without exemptions another rate. The whole faceless kind of assessment and the appeal process. So a lot of things have been gone really to actually project a transparent, and fair taxation and independent kind of system to both industry and individuals. And that's a very big positive. And this actually just enhances the reputation of the country and of the commitments made by the government.
Okay, Mr. Bhattacharya, your concluding views there, sir, on the issue of tax reforms. When we are talking about, there's been a lot of talk, a lot of discussion happening, and with the issue of retrospective tax taken care of, how do you think things might move from here onwards vis-a-vis the taxation issue?
Two or three things that we need to be watchful about. Number one is that the perception issue has been tackled in the sense that the government's intention with regard to how it sees the retrospectivity to capital gains tax levies are concerned. That perception issue has been tackled, number one. Number two, the government has to recognize that there is often a gap between the intention and reality. Now, the intention has helped address the perception issue, but the reality will depend on how soon and how quickly the tax apparatus or the tax administration apparatus is beefed up to address and ensure that the intent of the law is implemented in letter and spirit. And that cannot wait for even months because the time has already been lost in the sense that many months have gone by after the arbitral notices came, and there was this rather ignominious prospect of Indian properties being put up for sale by a foreign company after getting an adverse order against Indian assets abroad. Now, these things should be addressed quickly because this is an opportunity. And finally, I would say that it is an opportunity of addressing some stressed sectors like the telecom sector as well as the oil exploration sector, and both Vodafone and Cairn have actually have been hurt because of these legislative and these tax disputes.
Okay.
So therefore, hopefully, this will help turn the sentiment in these businesses around and attract more businesses and more investment into the sector. Finally, the good news is that resolution of this dispute does not mean much of a revenue hit for the government. Only around 8,000 or 9,000 crore rupees will actually go out of the exchequer because that is the only amount that was recovered from these companies. So it is not a huge amount which will actually have to go out of the exchequer. So the government can actually very well implement this law, not only in its letter, but also in its spirit.
Okay, indeed. Thank you so much, Mr. Bhattacharya, as well as Mr. Dilip Chenoy, for sharing your views and inputs. There it is, all about the Taxation Laws Amendment Bill 2021, which deals with the issue of retrospective tax, the details of how and why that particular tax was imposed, and what these amendments do. They indeed do away with the retrospective tax and let it be only from 2012 onwards, with obviously certain conditions for those companies which are involved in legal tussles out there. We'll keep you updated on all other details and related issues. Keep watching.